Welcome to this information session on the Data Availability and Transparency Act scheme. My name's Felicity Flack and I'm the Manager of Policy and Client Services at the PHRN. I'm speaking to you from the lands of the Whadjuk people of the Noongar Nation, and I'd like to begin by acknowledging the traditional custodians of all the lands we're meeting on today and pay my respects to elders past and present. The DAT Act may have a significant impact on the work that we all do, so we're very keen for everybody to have the opportunity to access the information they need to better understand the scheme. So today I'm delighted to have Simon Gallant, Senior Advisor at the Office of the National Data Commissioner, who has kindly agreed to give an overview of the scheme and answer any questions that you might have. If you've got any questions, please feel free to put them in the Q&A box at any time during the presentation, and then we'll take the questions at the end. So I'll hand over to Simon now, and we'll come back for questions later.
Thanks, Felicity. Hello, everyone. Nice to be with you today. I'm coming to you from the Ngunnawal country today, and I'm joined by my colleague, Fiona Rothschilds. So I will just share my screen and we will get into it. I've got a presentation that will take us about 15 to 20 minutes to get through. And then there will be plenty of time for questions. Felicity, can I just check that that's all working properly?
All good.
Excellent. I will get started then. So thank you again for coming. Today I'm going to run through a fairly brief presentation on how the scheme works and how we're supporting data sharing through our platform called DataPlace, which will include some information on becoming an accredited user under the scheme. I'll give a bit of a brief overview on what the Office of the National Data Commissioner is here to do, as well as running through the function of the scheme itself. And then I'll provide some information towards the end on how we can provide support to your organisations and ensure that you can be part of the scheme if that's what you choose to be. And then, as Felicity said, plenty of time for some questions and discussion after this. So, Office of the National Data Commissioner exists to be the national educator and regulator for the sharing of Australian government data under this scheme. Australian government data is defined as data that is held by Australian government agencies where those agencies have a right to deal with that data. Right to deal with is a fairly complex legal concept that includes things like intellectual property rights and copyrights, as well as the legal right to make decisions about data. So just because an agency has data doesn't mean it has the right to deal with that data. And in fact, there are some cases where an agency has the right to deal with data, but isn't the holder of the data. So the Australian government data that we are regulating and that is able to be shared under the data scheme is quite wide-ranging and quite deep in some places. And the ONDC is here to support the sharing of that data where that delivers a public benefit. We're also here to help build data sharing capability across the public service. We know that data sharing is something that happens well in pockets across the APS, but is not necessarily something that can be expected to be good in all parts of all agencies, and ONDC has a role in improving that. Obviously, ONDC is here to be an effective and efficient regulator and educator. We need this scheme to work well for a variety of purposes, all of which are benefiting the public, and we need to make sure that we're doing that in the most effective and efficient way that is possible. Finally, we are here to build trust and transparency in data sharing more broadly. We know that over the past 10 years, there's been a degradation of trust in government use of data from the public. And we believe that there are a large number of good things that can be done with data by government and with government data by the non-government sector, including universities and the private sector. But that has to be done in the right way and for the right reasons and communicated transparently to build that trust back up. So the big part of what we're here to do is to unlock those assets that are our nationally owned data. I mentioned before there are a few barriers to data sharing by government. Some are around culture, some are around legislative barriers, and some are around the complexity of existing data sharing agreements. Any of you who have worked with government in receiving data held by government agencies will know how long those agreements can take to negotiate and how complex they can be legally, and can also probably understand what we say when we refer to a culture of caution around data sharing. The research that was done a few years ago about Australian government data sharing showed that usually the position taken by agencies was we need to justify why data should be shared. And we believe that the improved data capability culture for best practice data sharing would be to reverse that and say the burden has to be, why should that data not be shared? We share by default, and we protect the data where it needs to be protected, but the decision should be, yes, we will share that data. What controls do we need to put in place to make sure that's safe? One of the critical parts of the data scheme that ONDC is the regulator of is an override provision in the Data Availability and Transparency Act, which allows Australian government agencies to share data that they have the right to deal with, where that would be counter to some other piece of legislation. So if there's a secrecy provision in an existing piece of legislation, the Data Availability and Transparency Act can override that secrecy provision where the right safeguards are in place and where it's in the public interest. When we say in the public interest, there are three purposes for which data can be shared under this scheme. Those are in that blue box on the right: improving government service delivery, informing government policy development and program design, and supporting research and development for public benefit. That supporting research and development for public benefit purpose does not have to be government research and development. That can be industry or university research and development, where the public benefit is clearly articulated and where the right safeguards are put in place to make sure the data is not misused. This page shows the entire scheme on a single page, and it is very complex in how the scheme safeguards are articulated. But I will spend about 5 minutes running through this page to give you a bit of an overview on how the scheme operates. The first thing to take note of is the top blue bar that includes the Act and the Commissioner and the Advisory Council. That is essentially the governance of the scheme. So the Act provides that legislative authorisation and override that I discussed before, and sets out what the appropriate safeguards are for sharing data safely. The Commissioner has a range of powers to make sure that those safeguards are used effectively and that only the right organisations are part of the scheme. And then the National Data Advisory Council is a group of about 10 government and non-government data sharing and data use experts who provide the Commissioner with advice on how the scheme should be put into operation. There are three roles created by the scheme. The first is that of data custodians. Data custodians are all Australian government bodies with a small number of exclusions. Those exclusions are largely law enforcement and national security bodies. So the Australian Federal Police and ASIO and parts of the Defence Department are excluded. So data held by those excluded agencies cannot be used or shared under the scheme. Accredited users is the second role created by the scheme. Any Australian government body with those exclusions, any state and territory government body, and all Australian universities can become accredited users under the scheme. Australian university, under the definition of the Act, is a university that is created by a Commonwealth, state or territory piece of legislation and is registered as an Australian university on the TEXA list of organisations. Accredited users can obtain and use Australian government data under this scheme by making a data sharing request and putting in place a number of these safeguards. The third role is that of accredited data service providers, and this is a key role in keeping the sharing of data safe, because all eligible entities, so same group as for accredited users, can apply to be accredited data service providers where they have sufficient technical expertise to do complex data integration, that is the integration of multiple data sets from multiple organisations, especially if there's a lack of good metadata, do de-identification services, and or provide a secure data access service, so an online data lab that another organisation can log into, for example. So an example of an organisation that functions like an accredited data service provider is the Australian Bureau of Statistics or the Australian Institute of Health and Welfare, where they have sufficient expertise to do de-identification in a robust way, and then can provide access to de-identified but unit level data through their data lab program, where a researcher can log in essentially to a remote desktop, access that data in a safe environment, and needs approval to take that data out of the environment once they've done their analysis. So we're expecting a number of other organisations to become accredited data service providers under the scheme, and there are definitely some expert areas within universities that we'd expect to see becoming ADSPs over the next year or so. The scheme safeguards, which is this U shape of boxes around the outside. I won't go into great detail on each one of these because we'd be here for hours. We've already spoken about the data sharing purposes, and I've mentioned the term accreditation a couple of times now. When we say accreditation, there is an application process that an organisation needs to go through to become an accredited user or an accredited data service provider. The accreditation authority for government data users is the Minister for Finance, and the National Data Commissioner is the accreditation authority for all other accreditation applications. The application for becoming a user is relatively straightforward, but you do need to provide quite a lot of information about how your organisation operates. And then the accreditation process for data service providers is significantly more complex, given the level of detail that we need to assess, especially around things like IT security for the secure data access, secure access services. One of the safeguards is the data request system itself. So in order to make a data sharing request, you do not have to be accredited to make that request, but data custodians only have to respond to requests from an accredited user. So if you, as your organisation, wishes to receive data, the best way to do that is to become accredited. Make that data sharing request of a data custodian. There's no guarantee that they will meet that request, but they do have to provide reasons. And when we say reasons, that is a formal administrative statement of reasons from the data custodian agency back to the accredited user if they're refusing the request. And that statement of reasons will need to say why they are refusing the request. And it can't be as simple as this is too hard. It will need to go into more detail. We do expect that custodians will have conversations with the requesters rather than just refusing. So there may be an iterative process whereby the request gets refined so that the user and the custodian can get the data that they're actually looking for. The next safeguard is the data sharing principles, and these must be applied to all data sharing under the scheme. The principles were developed from the 5 SAPES framework that's used for controlling statistical release by the ABS and by the UK Statistics Office. And they apply controls on the project, being why the data is being shared, the people who the data is being shared with, the settings being the IT environment that the data would be moving into, the data itself, including the sensitivity of that data and the level of detail that it goes into, and then the output. So what is actually being generated by a data analysis, including, are we generating a secondary data set? Are we just pulling out a report? Are we looking to publish information on the internet? All those sorts of things are covered by the output principle. Obviously, we're talking about sharing sensitive information under this scheme, and in particular, there is the likelihood that personal information can be shared. It's important to note that this scheme does not override the Privacy Act. There are a number of privacy protections built into the scheme, including the minimization of sharing personal information, blanket prohibition on re-identification, and prohibitions on the storage of data or access to personal information from outside of Australia. The simple way of thinking about the application of the Privacy Act here is that any data shared under the data scheme would be considered a new collection of data by the receiving agency in considering the Privacy Act. There are some exclusions around when consent needs to be sought for the sharing of personal information. They're not easy to meet. And there's a particular clause that says that simply there being a large number of individuals in a data set isn't a good enough reason to not seek their consent. And I can talk about that in a bit more detail later on if need be. But if there's ever a project that shares biometric data, so data that can be used to identify based on physical features, express consent is always required and there's no override available. I talked earlier about the complexity of data sharing agreements being a barrier to existing sharing, and data sharing agreements do exist under this scheme. However, because the purposes, requests, principles, privacy protections, etc., will be the same set for every data sharing project, those agreements will be much more streamlined. So when I say streamlined, I don't mean short. They're not a one-page agreement, because the application of data sharing principles and things like that is lengthy legal words, but they will be broadly the same legal words every time you do one of these agreements. So we will have a bank of clauses that can be drawn on to create the data sharing agreement, and that will all be built into the DataPlace platform, which I'll speak about in a moment. We talked briefly about data scheme transparency and reporting earlier. So there's a number of public registers that we'll keep on. So all data sharing agreements get registered publicly, and there will be a public list of accredited users and accredited data service providers. And then, of course, the Commissioner releases an annual report that talks about how the scheme's operating and who's participating. And finally, the Commissioner has a complaints monitoring, assessment, investigation function to make sure that the scheme is operating how we expect it to operate and that people aren't breaking the rules. And the Commissioner can issue directions and seek penalties if someone is doing the wrong thing. Finally, we're doing a couple of pieces of work to make this all as smooth as possible. The first is supporting agencies through our data discovery program in developing data inventories. And we're also building an Australian government data catalogue that will connect to existing tools like the Australian government digital atlas and data.gov.au, so that there will be one place that's searchable for all public open data, as well as data sets that are available through the scheme. And finally, DataPlace, which is our digital platform where scheme participants and others can manage data sharing requests. And it's also our administrative tool for the scheme. So all those accreditation applications, etc., go through DataPlace. So I've spoken a bit about why DataPlace is a good thing, and I'm conscious that I'm nearly over my 20 minutes already, so I won't go through this in great detail. I think most of you attending today have a very good understanding of why improved and increased data sharing would be a good thing. So there's a series of benefits here that are the sort of party line on why data sharing is a good thing. The one for you to really hang on to now is this accreditation for capability and safe sharing. In order to make sure that data shared under the scheme is done safely, we are limiting the participation in the scheme to those who become accredited, and only a small number of Australian organisations can become accredited. So to be very clear, Australian government organisations, state and territory government organisations, and Australian universities at the university level, not at a sub-organisation level, are the only organisations that can become accredited. And it's a way of minimising the risk of unauthorised access or use, and it ensures that we know who's participating, how they're participating, and how they intend to meet their obligations. I've spoken briefly about DataPlace just before, and the thing to take away from today's session on DataPlace is that if your organisation wants to participate in the scheme, the easiest way of doing that by far is to get the organisation onboarded to DataPlace. DataPlace is not a formal requirement of the scheme at this stage. It may become that later in its life, but at the moment, DataPlace is a helpful tool through which we are doing accreditation applications. And we are also looking to get a large number of Commonwealth agencies onboarded as custodian agencies so that requests can be directly submitted to them through DataPlace. DataPlace is also able to be used for making data sharing requests outside of the data scheme. So you do not need to be an accredited user to access DataPlace. And it is potentially a useful thing for organisations to coordinate the requests that they're making and potentially streamline the way that data sharing agreements are being made for both data scheme, shared data, and data that's being shared elsewhere under other mechanisms. The discovery project is how we're delivering these data inventories. We're looking at up to 20% of Australian government agencies by 2024. So that's about 45 agencies over the next couple of years. We're working with 14 as of the end of June, and we're looking at something like 25 by the end of this year. Each inventory is delivered using the same set of steps. So we understand the agency context, engage with multiple data areas in that agency, agree some standards and processes, collect the assets, consolidate the inventory, and present that inventory back to the agency with the end goal of the inventory then being available through the Australian Data Catalogue. This means that the catalogue will include a large number of entries for data that we know exists and we know who you should talk to get to, but is not publicly available. So this is our little slide on how we're working with participants to get this scheme implemented. And obviously we're a long way through this slide now. We're sitting in the middle of August, and the data scheme is well and truly open for business now. Over the past few months, I've been saying that from the 1st of August, universities will be able to apply to be accredited. That is all now true and live and ready to go. We've also released a number of pieces of functionality on DataPlace, and we're looking to open that functionality to make data sharing requests and come up with data sharing agreements in mid-October. We also have just today, in fact, released our consultation paper on the data code, which is the code of practice for how the data sharing principles should be applied, and some guidance on privacy and data sharing agreements. So that's all on our website now. Also on our website is consultation on some ministerial rules, including how a set of existing organisations called accredited integrating authorities become accredited data service providers, as well as how we keep a register of accredited data users useful to people. So, conscious of time, I'm going to talk quickly through user accreditation, because this is something that if you want to participate in the scheme, your organisation must be accredited. I think I've covered off pretty much everything on the left-hand side there now already. But the key takeaway here is that becoming accredited is sort of your driver's license, but it is not a car. So when you're granted accreditation, you can participate in the scheme, but that doesn't guarantee any data being shared with you. The data can only be shared with an accredited user in accordance with a data sharing agreement following a request to a custodian. There's a number of criteria for becoming an accredited entity, and those include having good data management and governance policies, having appropriate qualified individuals in some leadership position to make sure that that's being done properly, and has some IT security controls to make sure that shared data isn't going to be available to absolutely everyone in the organisation and is unlikely to be lost. And also that the organisation understands what skills it has and what capabilities it has and how those are managing the privacy, protection and appropriate use of data. So essentially you can think about accreditation as a first test of whether your organisation is able to meet the people and settings principles. So those being, can your organisation control who is able to access data inside the organisation from IT and access control perspective? And does your organisation know who's working for it, what skills they have, and how to make sure that only the right people touch sensitive data if it's shared with you? There's a bit of a checklist here for becoming an accredited data user. All of this information is available on our website, and Felicity's promised to share this slide deck with all of you afterwards. But essentially, there are a number of steps you need to go through to become accredited, and not all of those are just checkboxes on a web form. You do actually need to have a pretty good understanding of how your organisation functions from a data governance perspective to ensure that you can demonstrate that you can meet these criteria. So things like reviewing your organization's experience in working with data and skills within the workforce, that's not something that you can just say, yes, that exists. You will actually need to provide some evidence to say, here are the skills that we have, here is the experience that we've got, and here is how that would meet the intent of the accreditation system. We don't expect every accredited user to have already used government data or particularly sensitive data. We'll take it on a case-by-case basis, and we do expect that organisations who do a lot of data work currently will be able to provide some evidence that says this is how we work with it and these are the skills and capabilities that we have. It's also quite possible for the Commissioner to accredit a user with some conditions. So for example, if you work in a very small organisation that has a number of highly skilled individuals but doesn't have a really secure IT environment, we might say you're entirely able to become an accredited data user, but you can't hold the data yourself. You're going to have to engage an accredited data service provider to give you access to that data on a more secure system. So there may be a small group somewhere who can only access shared data under the data scheme through something like the ABS's data lab. And that's the end of the presentation for now. I can see a couple of questions in the Q&A, but if you've got other questions after this, feel free to reach out to information@datacommissioner.gov.au, and you could spell commissioner correctly, which we have failed to do on the slide. I apologise for that. I'll fix that before I send it around. There's also a contact us form on the website if you'd prefer to use that. And with that,
that's fantastic. Thanks, Simon.
Thanks, Lucy.
Nicola, I can't turn my camera on. So we're very happy to take questions now, and we've got plenty of time to do so. We've got a few in the Q&A box already, but please feel free to add some more, and we will, there I am. Okay, let's start with the first one, which appropriately is a data linkage one. Will data linkage units need to seek accreditation to become a data service provider? What if they choose not to seek accreditation?
So if the data linkage unit is currently an accredited integrating authority under the existing whole of government arrangements, all but a couple of those accredited integrating authorities will be transitioned by a ministerial rule to becoming an ADSP. If they choose not to become an ADSP, or if they're not currently an AIA, they won't be able to provide those services for scheme data. There's nothing we're doing that will stop you providing those services outside the data scheme or anything that you're currently doing. But if you want to essentially play in the data scheme sandbox, then you need to be accredited as either a user or a service provider.
So to summarise, essentially, if you want to play with Australian government data,
I think it's more nuanced than that, Felicity. That there is still a large amount of Australian government data that can be shared outside of the scheme. The scheme doesn't replace all data sharing agreements. And in fact, because of the depth of control required to share data under the scheme, I think there's likely to be a large amount of sharing that still happens outside of the scheme. But where organisations need to take advantage of a legislative override, so they can share something that previously they've been told is unshareable, then you would need to enter the data scheme. And if a data linkage unit wanted to work with that sort of data, then they need to be accredited.
So we might have already answered this question, but one of the other questions is, will the scheme override existing data sharing processes with data requesters or operate alongside it? So you might want
So it operates alongside and provides an additional pathway, like I said, where there has previously been an inability to share. So an example of this could be, and I don't want to put any agency particularly up front, but an example I know of is biosecurity information is currently protected by the Biosecurity Act. That there's probably some quite interesting research that someone can do about the movement of people and plants and animals under the Biosecurity Act, but that information was all collected by Department of Agriculture and can't be shared for anything other than a biosecurity enforcement purpose currently. If you used the data scheme to request that data for a research project, the Agriculture Department, should they choose to, would be able to take advantage of the override provision in the DAT Act to then share that data with you. So existing arrangements don't need to change. And like I said, I suspect there will continue to be quite a lot of sharing outside the scheme. This is an additional pathway.
So an example in the world that we all work in would be access to MBS and PBS data, which currently there is a legislative pathway to access. So, I mean, you could access it through the DAT, but you don't have to. There is an alternative pathway. Yeah. Next question. Would requesters who would like to access a combination of government and non-government data be able to apply through this scheme and to use DataPlace?
So the short answer is yes, and the more complex answer is the request to use government data would need to include the fact that there's a desire to combine that with non-government data, if that's what you're trying to do, because the way a custodian's likely to understand a request is about how that data is going to get combined with other data and whether that might lead to some risk for a member of the public or an inadvertent disclosure through a instantiation of the mosaic effect or something like that. So yes, for the government data, you can definitely use DataPlace to request that. At the moment, there's no plans to include non-government data holders as custodians on DataPlace. And in the first instance, it will only be Australian government data holders as custodians. We're looking at extending that out to state and territory government organisations as well. But I think it's unlikely that private sector or university data custodians you'd be able to make a request of them through documents.
Okay. Next question is about private sector access. So can the private sector access the data scheme?
No, they cannot. So the only organisations that can access data through the scheme are Australian Commonwealth, state, territory government organisations and Australian universities. So that actually limits the scope of who can participate quite substantially. And we know that there are a number of not-for-profit research organisations, for example, that can't participate because they're not part of a university, but it also excludes the entirety of the private sector.
And then a related question, can private sector access the scheme auspiced by a university? So I'm going to imagine they're thinking of a scenario where a private company might contract a university to do some research on their behalf.
Yeah, yes, possibly. So the scheme allows for what are called authorised arrangements. So it is possible that a private company contracts a university to conduct some analysis. There would then need to be quite a detailed understanding of the output of that analysis and what was shared with whom. So I think it's likely that a university would be able to receive some data under the scheme to do that work, but then the controls on what the university then shared with the private sector organisation would be really tight.
Okay. Next one is, are there any types of government held health data that are not likely to be covered under this scheme?
So my health record data is explicitly excluded from the scheme, as is some of the data from the COVID tracing apps. So some of the online collection tools that have been stood up in the last few years with explicit promises from government about that not ever being shared with anyone for any reason, those promises still hold. But the vast majority of government held health data, I think, is in scope.
Okay. And I don't know whether you'll know the answer to this question. Will this make access to MBS and PBS data held by the AIHW easier and cheaper?
It may make it easier because the pathway becomes the same each time you make the request, but I couldn't comment on cheaper.
Yes, take that up with the AIHW. Okay. Can data requesters or researchers access data from outside Australia if the data is stored in a secure research environment, I'm guessing in Australia?
I think I'm probably going to take this one on notice because there are some funny interpretations about what data stored or accessed from outside Australia actually means. The controls on no access from outside Australia is only relevant for personal information. So if it's been de-identified or aggregated up in some way, then I think it's probably okay for researchers outside Australia to access it if the data is in Australia. But there's likely to be some discussion between the ONDC and the data custodian about what outside Australia actually means from an IT perspective. If someone's using a university-owned laptop on a like an Australian university-owned laptop on an Australian university-owned VPN, is that actually substantially different from them sitting in an office in Sydney? I don't think it is, but that may not be how the law needs to be interpreted.
Okay, well, that'd be helpful if we can hear some more thoughts about positions on that in the future. Yeah. This next one, I'm not sure that you will know the answer to. How long does it usually take to get approval for government health data sets? And essentially is the question.
Yeah, so we know that requests take different amounts of time based on their complexity, and different organisations have different levels of maturity for understanding those requests. So I know that in speaking with the AETO, the tax office, a couple of weeks ago, they have a couple of teams dedicated to understanding data sharing requests, and some of them they can turn around in an hour and a half, and some of them take 18 months to negotiate. So my understanding is that health data sharing often takes months to negotiate. And our discussions with Department of Health so far have suggested that using the data scheme is likely to speed that up, but we have no evidence to prove that yet. It hasn't happened. The thing that would speed it up is the fact that the scheme requires the same controls to be implemented in similar ways each time. So it reduces the mental burden on the data governance people and on the legal people, because you're kind of churning through the same sort of agreement over and over again and making similar decisions each time you're given it, and not having to come up with anything from scratch. So I think there is a likelihood that things will be faster, but probably not the first time, and probably not even the 10th time. Maybe after the 50th time that similar data is shared in a similar way, we know the process and we know how it's going to work, and then it will be faster.
There was a second part to this question, which was, are there any ways to make all data publicly available so that it would benefit researchers and program planners?
No, but so that yes, you could make all data publicly available. I don't think there's any appetite for that to actually happen. What we are expecting is that data custodian agencies will start seeing the same sorts of requests over and over again, and will therefore be much more responsive to those requests in future, or will work with multiple requesters to say, if we aggregated it at this level, we'd be comfortable releasing it publicly. Is that still going to be useful to you? Because what we need to balance there is, I think given what happened with the release of MBS PBS data on data.gov.au about 8 years ago that was not properly de-identified, I suspect the health and services agencies are very unwilling to release unit level data publicly, regardless of the level of obfuscation that's been applied. But there may be some middle level that is still useful for researchers and is safe for release. But that's something that I think would be quite a complex exercise.
I agree. Next one says, helpful presentation, thank you. As a linked data user who works for a national NGO, have I understood correctly that the current access and approval processes facilitated by the PHRN remain available to me, including where this involves Commonwealth linked data? I might answer that question. The answer is yes.
Yes. So everything that is currently happening can still happen.
Yes. Next one is, can we get some more information on the auspicing arrangements, authorised arrangements? I think that might hark back to an earlier question talking about arrangements with private sector, with academic partners doing the research.
So I'll take that one on notice, Felicity, and get some solid words from our policy folk. We have had a similar discussion to this in whether a non-government data provider could provide ADSP-like services under the banner of a government organisation, and the short answer to that was yes, if there's enough legal documentation and controls around it. So we'll get some more information on how those authorised arrangements function. But the thing to keep in mind there is they function at a project level. You can't, there's no, we couldn't stand up a standing arrangement under the accreditation of an organisation that said this organisation's accreditation also applies to work from some non-government organisation.
Sure. Okay. Managing and providing access to big data has always been challenging. How can multi-country studies data be managed?
Excellent question, and one I probably don't have a very good answer to. I agree that managing and providing access to big data has always been a challenge. I'm not aware of multi-country data held by Australian government agencies. And my cop-out answer to this would be only the data that Australian government agencies have the right to deal with is in the scope of the data scheme, and therefore that's all I can really give advice on. But I think the more useful answer is those accredited data service provider agencies and other data linkage units, I think are probably much better placed than ONDC to provide guidance around that.
The next one is possibly tricky. How does the data scheme operate with FOI, so freedom of information? Does the fact data is within the scheme limit the reach of the FOI legislation as a mechanism to seek the same information? For example, the AHW legislation explicitly limits FOI legislation so that FOI laws can't be used to get AIHW data.
Yeah, so the freedom of information legislation is essentially a way to force agencies to release things publicly, and the data scheme, it doesn't prevent public release of data, but the public release of a data set in its entirety through the data scheme is extremely unlikely, because when you're sharing data under the data scheme, the likelihood is that that's sensitive in some way, which is why you're using the relatively complex data sharing principles and entering into a 40-page data sharing agreement and taking advantage of a legislative override. It's very unlikely that that data sharing agreement says, and then you can put it all on the internet and it'll be fine. So I think there's the FOI Act and the data scheme, both are likely to provide access to information, but for quite different purposes, because a release of information under the FOI Act is essentially as a public release. And I think very, very unlikely that we get public releases of large data sets under the data scheme. So they will interact a little bit in that I wouldn't be surprised to see some organizations turn a data scheme request into an FOI request or vice versa if they don't get an answer they're happy with. But given the way that output of those two requests would form up, I don't think there's much overlap really.
Okay. The next question, which might be helpful to reiterate, is what data are available through the scheme?
Yeah, so the short answer is almost all data held by Australian government agencies is available through the scheme. So again, a couple of exclusions from the security and policing side of things, as well as operational data held by the Australian Border Force and My Health record data. Almost everything else is in scope. The complex part of that question is there's no list of all Australian government held data. So through the data discovery program, we are hoping to create a list which will cover off the major data assets held by about 45 agencies by the end of 2024. And the agencies we're working with are the big departments who hold a lot of the data and some of the smaller agencies that hold a lot of data. So that will be the best place to search for what is available. But currently the only way to know whether something's available or not is to ask for it and see what response you get, which we know is not good enough.
Sure. Next one, you mentioned that universities can be accredited, but not specific subunits of the university. What happens in the case where a data linkage unit sits within a university? Can that unit apply for accreditation in its own right?
So the unit can't apply for accreditation in its own right. The university as a whole has to apply, but the conditions on the accreditation could say that only the data linkage part of the university is able to fulfill the function. So that's a bit of a backwards way of answering that question. But if University A has only one data linkage unit in it, and that's the only part of the university that ever is going to provide those services, then the university as a whole gets accredited with a condition that says only staff working in that linkage unit are able to do these things. So essentially it becomes the linkage unit being accredited, but the legal document will say the university is accredited. Where there are multiple linkage units in a university, the accreditation conditions could say only those people in those multiple linkage units, or that research school or something like that. So the accreditation has to happen at the organisation level, the university level, but the conditions on the accreditation can limit which research schools, which researchers, if need be, and which linkage units are actually able to provide the services. So we do not expect a university to have to make strong security and data governance requirements of the School of Fine Arts so that the health research people can access data.
Good. Okay, I think that's clear. Does the DAT Act plan to replace other means of accessing Australian government data in the long term, or will there always remain a parallel or alternative means to access data?
So the Act and the scheme would only replace everything in the long term if it was easier for everyone. So if Dataplace provides a simple way for people to request data, and then the custodian agencies are finding it easier to share data under the scheme than outside of the scheme, then the Act may replace everything over time kind of by default, but there's no timeframes for that to happen in a mandatory sense.
Sure. Okay. Do you expect that universities will have to set up its own internal application process for vetting? I'm guessing researchers who might access the data within that university setting. Will the office provide a system for this or use the Australian Access Federation?
So the way an organisation manages who is able to access something is up to the organisation, and we can't play a role in that because it would turn into identity management for 15,000 organisations, and that's not something we're capable of doing. Australian Access Foundation, I think, is a reasonable way of looking at that. But
so would you need to, when you're applying to become an accredited user, do you need to explain how you're going to decide who can access the data or not?
Yeah, that's right. And that can be as simple as only these people working in this organisational unit will have access, and this is how the IT security controls are applied, or something like that. Or it can be a more complex and nuanced way of saying anyone in the organisation with this set of skills assessed against these criteria will be given access, something like that. But the management of that access is up to the organisation.
The next one, would cross-institutional research centres such as CRCs and centres of excellence be able to apply, I'm presuming to be accredited users, or researchers have to go via their home institution?
So you have to go by the home institution. So I'm not quite sure on how the CRCs and centres of excellence are set up legally, whether they become hosted by a single university or if they're sort of a joint venture type arrangement. But again, it's the universities themselves who would have to become accredited, and then the CRC would leverage that accreditation. So they're not a university in their own right, so they have to leverage the broader accreditation.
Sure. I'm not exactly sure on this one. Could a new entity apply for accreditation? I'm wondering if they're meaning somebody who's not currently an integrating authority. Not sure. What are their chances given qualifications and experience of people involved?
So the short answer is yes, an entity that doesn't exist now could apply for accreditation if they are an eligible entity. So if a new university was created, that university could apply for accreditation. If a new government agency is established, that agency can apply for accreditation. So it's not about organisations that exist now. It's about whether organisations fit into that category of eligibility. So if a university that doesn't currently have a data linkage unit established a data linkage unit with people who had the right skills and qualifications and experience, that linkage unit could then apply as part of the university for the university to be accredited with those conditions, and use the experience and the qualifications of the individuals involved in the linkage unit as evidence that they have those appropriate skills and qualifications.
The next couple of questions I'm going to ask, because I think it'll be helpful to distinguish what the DAT scheme is and what it's not. So the next one is, are there any plans for a data lab at some point?
Not from, we would see the data labs as being something that those accredited data service providers have. So ABS has one that's open to researchers now, and we expect a large number of other organisations to stand those up over the next few years.
Sure. And the next one is, could you share more about data validity and quality? This person's working on general practice data set, but has having trouble with incompleteness and data quality. But the answer is the DAT scheme is not really about data quality or validity. That's up to the data custodians.
Yeah, that's correct.
Yeah. Okay. I've got maybe one or two other questions, and then I think we might have got through them all. Does the data sharing agreements within the scheme apply to non-government data sharing agreements? For example, data sharing agreements with clinical quality registries and things like that?
No, it doesn't. So the data sharing agreements under the scheme and under the Act only apply to data shared as part of the scheme.
And finally, about criteria for accreditation. In the bill, they talk about necessary data skills. Can you give us any indication of what's defined as necessary data skills?
So I don't think there's a really solid definition of that yet, unless it's in the data code. But I think it's a bit of a common sense approach that we're trying to take to that. So necessary data skills would be essentially based on, so when you submit I'll roll back a step because it'll make more sense if I tell it as a story. When you submit an accreditation application, one of the things we ask is, what sort of information are you looking to access under the scheme and what do you want to do with it? So if your organisation comes in and says, we're looking to access MBS PBS data because we've got interesting research projects to achieve these public benefit outcomes, the necessary skills are the ones that would apply to that sort of data. So we'd expect you to be have people in critical roles who have a really good understanding of de-identification and have a really good understanding of statistical disclosure, and then some subject matter expertise in what the research project you're doing actually means. So those skills and experience will be different to the skills and experience needed to do spatial mapping of threatened species. So we haven't given a definitive list of what those skills and experience are because it is dependent on what the organisation is trying to achieve and what data they're trying to work with. But I think it's reasonably safe to assume that if you've been working in a university or a government data area for a few years and have had successes in doing the right thing over and over again, you've probably got the skills and experience that's needed. So we're not going to say you have to have, everyone in the project has to have a PhD in data science. It's more about making sure that the people who are working on the project have the right set of skills as a cohort to make sure that they're not going to do crazy things.
Okay, I think I might leave that as the last question and say thank you so much for answering all of those questions. And obviously lots of people, lots of questions, so that was really, really helpful. And perhaps to say will you come back another time if we have more
Certainly.
questions?
Yeah, absolutely. Very happy to. And I will fix the typo on our PowerPoint and send that so it can be sent around and get some more information on how the authorised arrangements can work.
That would be really helpful. And just to let everybody know that we have recorded this presentation, so we will put that up on our YouTube channel and we'll let you know when that's available as well. So thank you very much, Simon. That was really, really helpful.
Thanks, Felicity, and thanks everyone for coming along.
See you.